Okay, so in the previous video, we found Campbell, which is this big U.S. Supreme Court case that really changed the landscape of things. We have a definition of parity, which goes to our second factor. We also found the Oracle case. So we're just going to keep going, keep finding cases, and so I'll show you what's next. So as I read, I'm continuing to read in this Nimmer on copyright treatise, and after the Campbell case, several paragraphs down, reread this one, and this made my heart sink. Eagles legend Don Henley filed suit against a Republican assemblyman in California, posted YouTube videos, and they had, whoever posted the videos, modified lyrics from Henley's songs. Although recognizing the time-honored First Amendment activity of mocking public figures through their own creations, the court concluded that the ditties in question failed to target Henley either at all or in any meaningful way. Given that defendants did not take a portion of the song or alter the melody, okay, this is us, they took virtually everything for the purpose of satirizing the politicians rather than targeting Henley. The decision granted summary judgment denying the fair use defense. Okay, so this does not look good. So Eagles, Don, Henley, I agree with the case. It sounds like a great case. It's just not good for our client. All right, Henley versus DeVore. So let me go to that actual opinion here. Okay, so y'all know Don Henley, founding member of the Eagles. So two of these songs, Boys of Summer and All She Wants to Do Is Dance. Those are kind of the songs at issue here. So this is very similar to what we have, where they downloaded a karaoke version of the music, the instrumental track, and then they put their own vocals to it. Okay, this is exactly what we have going on in our case. So let's see how they did. So by the way, these are all black letter rules here you can see from all of the citations. And let's see if there are any that might apply to us. I kind of like this broad definition. Fair use has been described as a privilege in others than the owner of the copyright to use the copyright material in a reasonable manner without his or her or their consent. So I'm going to grab that and put it in our plan. And because it's kind of a general rule, I'll put it up here at the top. Okay, so I just put it in right here. And note this is from a district court in California, but it's cited to a U.S. Supreme Court case. So I should really go to this Supreme Court case and grab it from there, because the Harper case would be binding. So I'm not going to do that. Obviously, it'll just take time, and you don't need to watch me do that. So what I'll do is I'll just make a note here. The source is actually this other case. So later in my document, I can get it from Harper. So here they're going through each of the factors. Like here's the first factor, second, third, and fourth, and they give a little black letter rule for each one. So I'll actually take each of these rules, and that could be the beginning of that section in my document. So I'm going to take some of these rules and put them in my plan. Okay, so you can see here I added these definitions that kind of define each factor. So there's factor one. I actually started with factor two, given our new Oracle opinion. Okay, and then I just went through. There's factor one, factor two. Here's factor three and four. I just kind of gave those definitions we got right from the Henley opinion right here. So after they do that in this Henley opinion, they then just go through Campbell and explain Campbell. And so we already know about Campbell, so we can kind of cruise through this. Okay, however, it is important to distinguish between a use which directly targets the author for holding a particular view and a use which merely targets a view that happens to be held by the author. So that's pretty damning. You can't even say that Hey Jude, that Hey Prof is really saying anything about the Beatles or the song or the lyrics. It's just kind of a nice tune to use. So I'm adding that to our plan under that first factor, the purpose and character. Okay, so I just added it right here. Now, we can tell from our citation here that this is a United States District Court, the Central District of California, which obviously carries less, weight. It certainly is not binding, it's only persuasive authority. But because the facts are so straight on, and because they apply Campbell, which is definitely binding, being from the U.S. Supreme Court, this does carry quite a bit of weight, and it is quite damning for us. So right here under this second factor, or I'm sorry, the first factor, where they're talking about parody versus satire and things like that, I would add a little description here of Henley. Do it like a case illustration of the facts, the holding, and the reasoning. Okay, so I just did a quick write-up. You can pause and read this if you want, of what the court basically said. Now, the point of this isn't to teach you how to write a memo or a brief, so this is all just rough draft, but these parts will become the actual brief or memo that I'm going to write. Okay, so I'm going to go back to our treatise here and see if there aren't any other cases that might be helpful or on point. Okay, here's another case based on Family Guy where somebody stole the music. When you wish upon a star, and rewrote the words to it, which is exactly our case. So this is the Bourne case, and in this case they said it was actually parody because they made a case that the lyrics, it's kind of making a comment on the lyrics of When You Wish Upon a Star. So I'm going to add that to our plan. Okay, now just imagine that I read this case, I did a full write-up on it. So now we have three cases. We have the Campbell case, we have the Don Henley case, and then we have the Bourne case. So basically, to synthesize these cases, if it's a parody that transforms the original by commenting on the original, then that is transformative enough, and that first factor really weighs heavily in finding that it is a fair use. And it seems with these parody cases, it all comes down to that. That's kind of the biggest factor. But if there's like even a snowball's chance in hell of an argument that somehow you're commenting on the original, then you can win. So when we write this up, when we write up our arguments, the reasoning that we're getting here is basically if there's some way we can turn make this argument that Hey Prof is saying something about Hey Jude, then we might have a chance, but I'm not really feeling it. So then for the case law we'd end up using, to go back, this is page 1, kind of the 4 goals of research. We'd use Campbell, Henley, and then that Bourne case. And then, for argument, if we can somehow say that Hey Prof is commenting on something in Hey Jude, then we might win. So that's where my thoughts are mainly at. Okay, so let me do just one last video where I put all this in an outline form so you can see how this translates to the final document. Okay, so I'll see you there.